At the First District Court of Appeal Tuesday, Charlie Adelson's attorneys focusing on the argument that potential jurors within the jury pool were tainted by media coverage about Dan Markel's murder, impacting their impartiality. I'm Mayor Sargent, your neighborhood reporter in Southeast Tallahassee. Judges' questions then centered around where the evidence was to show this, and without it, whether it causes the court to have to speculate.
Good morning and welcome to the First District Court of Appeal. We have one case on the docket today.
Michael Ufferman, Charlie Adelson's attorney, and Robert Charlie Lee for the state, sharing their arguments for and against Adelson's appeal. One of Ufferman's main arguments focusing on what he believes to be a lack of an impartial jury. He says 40% of potential jurors that were screened already had a preconceived idea that Adelson was guilty.
When you talk about 40%, when you talk about the judge making a finding when granting the protective order pre-trial, that Tallahassee is in fact a small community. When you talk about this case has been permeating Tallahassee media sources for almost a decade at the time of this trial.
Ufferman brought up instances where potential jurors were seen to have been lying about their knowledge of the case and posting it on social media.
Where that juror had said, surprise, surprise, Mr. Adelson is charged.
Ufferman also mentioned the amount of pre-trial publicity around Dan Markel's murder that he believed tainted the jury. Yet Judge Laurie Rowe mentioned that could not be quantified because no affidavits had been filed prior to the trial by the trial defense attorney, therefore raising a concern of speculation.
What you don't have in this record is how many times those exposures happened, whether they were biased or not, whether there were some broadcasts or podcasts that in fact argued that your client was innocent.
Criminal defense attorney Tim Jansen, who's been tracking the case, mentioned that's something to consider. How do you know if someone is lying? Which he believes does require some speculation.
And the question is, was it the saturation enough? 10 years of a trial, 5 trials. These jurors claiming, was that enough that he didn't get a fair jury? That's a good question.
The state countered, saying that no record was established by the defense counsel in the lead up to the trial and that credit must be given to those jurors selected.
Just because this young man said that Mr. Adelson was guilty and another man may have forgotten what he posted on Facebook about Mr. Garcia, that doesn't mean that the entire jury pool was tainted.
Adding that Mr. Adelson and his counsel were asked if they agreed to the jury in the trial. Following the hearing, Ufferman doubled down on his arguments that a new trial is needed because of the amount of publicity.
We need to have confidence that the jury, the 12 jurors that ultimately determined my client's guilt, were not improperly exposed to other jurors' opinions about my client's guilt and could be impartial, and I have severe doubts as to whether or not that occurred in this case.
The first DCA tells me judges now have 180 days to submit an opinion, deciding if they will overturn the ruling. In Southeast Tallahassee, Mayor Sargent, ABC 27.